Hello and welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload content every day at 8 a.m. Eastern Standard Time. If you like the content, please like, subscribe, and click the notification bell so you can be updated every time we upload new content. Let's move on to question number 1. Debtor's $1,000 contractual obligation to aunt was due on July 1st. On the preceding June 15th, aunt called niece and said, "As my birthday gift to you, you may collect on July 1st the $1,000 the debtor owes me." Aunt also called debtor and told him to pay the $1,000 to niece on July 1st. On July 1st, debtor, saying that he did not like niece and wouldn't pay anything to her, paid the $1,000 to aunt, who accepted it without objection. Will niece succeed in an action for $1,000 against debtor? A, yes, because aunt had effectively assigned the $1,000 debt to her. B, yes, because aunt's calls to niece and debtor effected a novation. C, no, because aunt's acceptance of the $1,000 without objection was in effect the revocation of a gratuitous assignment. Or D, no, because debtor cannot be compelled to render performance to an assignee whom he finds personally objectionable. Take 10 seconds and see if you can figure this one out. I hope you chose C, because it doesn't seem you need a law degree to choose that one here of these four choices. No, because aunt's acceptance of the $1,000 without objection was in effect the revocation of a gratuitous assignment. An assignment is the transfer of the rights or benefits under a pre-existing contract to a third party. An assignment without consideration is a gratuitous assignment. Gratuitous assignments are freely revocable. In this case, aunt gratuitously assigned the $1,000 debt that which debtor owed to the niece. Debtor paid the $1,000 to aunt instead of niece. When aunt accepted the $1,000 from debtor without objection, she effectively revoked her gratuitous assignment to niece. This means debtor is not liable to niece for the $1,000. As such, niece will not succeed in an action against debtor for $1,000 because aunt's acceptance of the $1,000 without objection was in effect the revocation of a gratuitous assignment. If we look at options A, yes, because aunt had effectively assigned a $1,000 debt to her. Well, again, we note the fact that it was a gratuitous assignment, which is revocable at any time. That being said, it would be injusticious to have debtor pay the $1,000 twice if he's paying off his loan. In fact, to the individual, he actually, in fact, borrowed the money. You would think logically then that niece would address that issue with aunt rather than with debtor. B, yes, because aunt's calls to niece and debtor affected a novation. While in fact, again, we're looking at a gratuitous assignment, not a novation. So the reality is that that assignment was in fact revocable at any time. Or D, no, because debtor cannot be compelled to render performance to an assignee whom he finds personally objectionable. The fact that he finds the niece personally objectionable is irrelevant, and at the end of the day, the reality is that he would not be liable to niece simply because he in fact paid the money back to aunt, who had granted the gratuitous assignment to niece only. So as a result, C is the correct answer. Question number 2. Miller is tried for armed robbery of the First Bank of City. The prosecution, in its case-in-chief, offers evidence that when Miller was arrested one day after the crime, he had a quantity of heroin and a hypodermic needle in his possession. The evidence should be A, admitted to prove Miller's motive to commit the crime, B, admitted to prove Miller's propensity to commit other crimes, C, excluded because its probative value is substantially outweighed by the danger of unfair prejudice, or D, excluded because such evidence may be offered only to rebut evidence of good character offered by the defendant. Take 10 seconds, see if you can figure this out. If you chose option C, you're on a great streak. Excluded because its probative value is substantially outweighed by the danger of unfair prejudice. The court has the discretion to exclude relevant evidence if its probative value is substantially outweighed by unfair prejudice. Confusion or waste of time. Here, the heroin and hypodermic needle might have some probative value by showing Miller had a motive for robbing First Bank of City. However, the unfair prejudice to Miller by being categorized as a heroin user substantially outweighs its probative value. As such, the evidence should be excluded because its probative value is substantially outweighed by the danger of unfair prejudice. If we look at option A, admitted to prove Miller's motive to commit the crime, there is no actual connection between the heroin and the crime in question, other than there could be some sort of assumption. The assumption would generally not be permitted as evidence of either the commission of the crime or anything else. So that in and of itself would generally be excluded. B, admitted to prove Miller's propensity to commit crimes. While this is not a similar crime, so ultimately if the argument were that the crime in question was similar to the crime which he could have been charged with, i.e. if this current crime were a drug possession crime, perhaps the evidence would come in, but they're entirely different and factually unrelated. So B would not be a good answer, nor would A, as we just discovered. D, excluded because such evidence may be offered only to rebut evidence of good character offered by the defendant. While that may be accurate, that being said, it's not especially responsive to the question here. Secondarily, it does not seem that this would be character evidence that's attempting to be introduced, but more so the evidence would seemingly be introduced for the purposes of showing a propensity towards criminality, which would generally not be permissible. So as a result, C would be the only correct answer. Question number 3. Dieter parked her car in violation of a city ordinance that prohibits parking within 10 feet of a fire hydrant. Because Grove was driving negligently, his car sideswiped Dieter's parked car. Plaintiff, a passenger in Grove's car, was injured in the collision. If plaintiff asserts a claim against Dieter to recover damages for his injuries, basing his claim on Dieter's violation of the parking ordinance, will plaintiff prevail? A, yes, because Dieter was guilty of negligence per se. B, yes, if plaintiff would not have been injured had Dieter's car not been parked where it was. C, no, because Dieter's parked car, was not an active or efficient cause of plaintiff's injury. Or D, no, if prevention of traffic accidents was not a purpose of the ordinance. Take 10 seconds and think this through. If you chose option D, no, if prevention of traffic accidents was not a purpose of the ordinance, you'd be correct. The negligence per se doctrine applies when a safety statute has a sufficiently close application to the facts of the negligence case before the court. There are 2 requirements in order for the statute to apply to the facts. The plaintiff must be a member of the class of persons whom the statute was designed to protect, and the statute must have been intended to prevent against a particular type of harm suffered by the plaintiff. An unexcused violation of a safety statute conclusively establishes that the defendant was negligent. In this case, the city ordinance was most likely intended to keep fire hydrant access clear, not to prevent against traffic accidents. If the ordinance was not intended to prevent against traffic accidents, then Dieter's violation of the ordinance would not establish Dieter's negligence per se in causing plaintiff's harm when Grove's car sideswiped Dieter's parked car. Accordingly, plaintiff will not prevail if prevention of traffic accidents was not a purpose of the ordinance. In analyzing the other choices, A, yes, because Dieter was guilty of negligence per se, we see that in fact Dieter was not guilty of negligence per se because the statute was not, in fact, or the ordinance, better said, was not in fact created to attempt to protect against this type of harm. So A is not relevant. B, yes, if plaintiff would not have been injured had Dieter's car not been parked where it was. That is generally not the standard presentable for any negligent or any injury case. So as a result, B would be excluded simply because it misstates the standard. C, no, because Dieter's parked car was not an active or efficient cause of plaintiff's injury. Again, we're back to the efficient cause of plaintiff's injury. This is outside of the standard, outside of the scope of the standard. So A through C are not relevant, not appropriate, and outside of the proper standard. D, as a result, is the only option. Question number 4. Tom had a heart ailment so serious that his doctors had concluded that only a heart transplant could save his life. They therefore arranged to have him flown to a big city to have the operation performed. Dan, Tom's nephew, who stood to inherit from him, poisoned him. The poison produced a reaction which required postponing the journey. The plane on which Tom was to have flown crashed, and all aboard were killed. By the following day, Tom's heart was so weakened by the effects of the poison that he suffered a heart attack and died. If charged with criminal homicide, Dan should be found A. Guilty, B. Not guilty because his act did not hasten the decedent's death but instead prolonged it by 1 day, C. Not guilty because the deceased was already suffering from a fatal illness, or D. Not guilty because the poison was not the sole cause of the death. Take 10 seconds and see if you can choose the correct answer. I hope you didn't overthink this. The answer would be A, guilty. The 4 elements of a crime consist of a guilty act, a guilty mind, concurrence, and causation. Actual cause can be determined by asking whether the harm would not have occurred but for the defendant's act or failure to act. Proximate cause is the philosophical connection which limits liability to consequences that bear some reasonable relationship to the actor's conduct so as to not offend notions of common sense, justice, and logic. On the bar exam, every murder is second-degree murder unless you're specifically told otherwise. Second-degree murder is the intentional killing of a person with malice and aforethought. Malice aforethought exists if there is no excuse justifying the killing. No adequate provocation can be found, and if the killing is committed with one of the following states of mind: intent to kill, intent to commit great bodily harm, depraved heart killing, or intent to commit a felony. Here, Dan poisoned Tom with the intent to kill Tom because Dan stood to inherit from Tom. Tom's heart was so weakened from the poison that he suffered a lethal heart attack. Dan's action of poisoning Tom caused Tom's death. All of the elements for criminal homicide are satisfied, so Dan, in fact, should be found guilty of murder. Now, if we look at option B, not guilty because his act did not hasten the decedent's death, but instead prolonged it by 1 day. The mere fact that his choice caused him to miss the flight and not die in the plane crash now does not grant him the opportunity to subsequently kill him. So as a result, B is not appropriate and would not be a correct answer. C, not guilty because the deceased was already suffering from a fatal illness. That being said, the illness in and of itself did not kill the decedent, but the actions of the defendant. So as a result, the defendant could still be charged. So then, C is not an appropriate response. D, not guilty because the poison was not the sole cause of death. In fact, the fact that the heart was weakened and the poison caused the death as a result of the weakened heart is a perfect example of what we call the Eggshell Doctrine. You take your victim as you find them. So given the fact that his heart was weakened, that would not be relevant for the purposes of defense, nor could there be a defense based on the idea that the poison was not the sole cause of death. There is no joint and several liability in these types of things. It's either guilty or not guilty. And the correct answer, given this fact pattern, is A, guilty. Question number 5. On March 1st, Hots Apartments, Inc. received from Cool Air, Inc. a letter offering to sell Hots 1,200 window air conditioners suitable for the apartments in Hots' buildings. The Cool Air offer stated that it would remain open until March 20th, but that Hots acceptance must be received on or before that date. On March 16th, Hots posted a letter of acceptance. On March 17th, Cool Air telegraphed Hots to advise that it was revoking the offer. The telegram reached Hots on March 17th, but Hots' letter did not arrive at Cool Air's address until March 21st. As of March 22nd, which of the following is a correct statement? A, the telegram revoking the offer was effective upon receipt. B, the offer was revocable at any time for lack of consideration. C, the mail was the only authorized means of revocation. Or D, under the terms of Cool Air's offer, Hots' attempted acceptance was ineffective. Take 10 seconds. Choose the best answer now. If you analyze the facts and chose option D under the terms of Cool Air's offer, Hotz's attempted acceptance was ineffective, you'd be correct. The rule is that a written offer for goods signed by a merchant promising it will be held open is irrevocable for the stated time period or reasonable time if no period is stated, but in no case will the offer be irrevocable for longer than 3 months. Of course, unless the offer provides otherwise. In this case, Cool Air's firm offered was irrevocable until March 20th. However, Cool Air's offer required that acceptance must have been received on or before March 20th to be effective. This freedom to contract eliminated the mailbox rule, which would have created a valid contract on Hotz's dispatch of his acceptance on March 16th. Since Cool Air did not receive Hotz's letter until March 21st, Hotz's attempted acceptance of this offer was in fact ineffective. If we look at the other options, option A, the telegram revoking the offer was effective upon receipt. That's inaccurate because the contract was up and through March 20th. So arguably, you could challenge or you could theoretically present a reason for breaching, but in and of itself, the offer was still in fact effective. B, the offer was revocable at any time for lack of consideration. That is absolutely inaccurate. There was consideration. There would have been, in essence, a payment due, and there was an agreed upon and negotiated time frame in which the purchaser would make purchase and would make payment with regards to the 1200 window air conditioner units. C, the mail was the only authorized means of revocation. That is inaccurate. There is no statement of facts in the fact pattern that states this to be true. As a result, the only option we're left with is option D. Question number 6. Barnes was hired as an assistant professor of mathematics at Riordan State College and is now in his 3rd consecutive 1-year contract. Under state law, he cannot acquire tenure until after 5 consecutive annual contracts. In his 3rd year, Barnes was notified that he was not being rehired for the following year. Applicable state law and college rules did not require either a statement of reasons or a hearing, and in fact, neither was offered to Barnes. Which of the following, if established, sets forth the strongest constitutional argument Barnes could make to compel the college to furnish him a statement of reasons for the failure to rehire him and an opportunity for a hearing? Option A. There's no evidence that tenured teachers are any more qualified than he is. B. He leased a home in reliance on an oral promise of reemployment by the college president. C. He was the only teacher at the college whose contract was not renewed that year. Or D. In the expectation of remaining at the college, he had just moved his elderly parents to the town in which the college is located. Take 10 seconds, choose the best option. If you chose option B, he leased a home in reliance on an oral promise of reemployment by the college president, you'd be correct. The Due Process Clause prohibits state actors from depriving a person of life, liberty, or property without due process. The government must provide a fair process before it may deprive a person of life, liberty, or property. Property here is defined as the loss of entitlement. An example of fair process is notice and opportunity to be heard. Here, the applicable state law and college rules did not require either a statement of reasons or a hearing after Riordan State College notified Barnes he was not being rehired for the following year. Barnes also does not have the reasonable expectation of the continued receipt of a benefit because he had not acquired tenure at the time of his termination. However, if Barnes had leased a home in reliance on an oral promise of reemployment by the college president, then Barnes could show he had a reasonable expectation of continued receipt of a benefit. That was created by this oral promise. If Barnes had a reasonable expectation of the continued receipt of the benefit, the college must provide a fair process before depriving him of this interest. Thus, Barnes leasing a home in reliance on an oral promise of reemployment by the college president would set forth the strongest constitutional argument that Barnes could make to compel the college to furnish him a statement of reasons for the failure to rehire him and an opportunity for a hearing. If we look at the other options, A, there's no evidence that tenured teachers are more qualified than he is. The qualifications are really not in question, nor are the qualifications a basis for him receiving the constitutional protections promised under the Due Process Clause. So as a result, A is irrelevant. C, He was the only teacher at the college whose contract was not renewed that year. There's no claim here of an equal protection type of scenario. There's no claim that this teacher is of a protected class. As a result, C would be irrelevant. It could be that he was the only teacher that had a terrible reputation, or he was the only teacher that sucked. D, in the expectation of remaining at the college, he had just moved his elderly parents to the town in which the college is located. Here we have a unilateral error situation. There is nothing promised to him. He had the expectation of himself on his own. That is not a basis for the college to be liable. B would be the best and only reason, given the fact pattern presented, that the professor would be entitled to the constitutional protections under the Due Process Clause. Question number 7. Miller's tried for armed robbery of the First Bank of City. The prosecutor offers the testimony of a bartender that when he saw the money in Miller's wallet, he said, "You must have robbed the bank," to which Miller made no reply. This evidence is A, admissible to prove that Miller's conduct caused the bartender to believe that Miller robbed the bank. B, admissible as a statement made in the presence of the defendant. C, inadmissible because it would violate Miller's privilege against self-incrimination. Or D, inadmissible because Miller had no reason to respond to the bartender's statement. Take 10 seconds. Again, I hope you didn't overthink this one. It would be D, inadmissible, because Miller had no reason to respond to the bartender's statement. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that statement. The hearsay exemptions are admission of a party opponent, vicarious party admissions, and prior statements by witnesses. The hearsay exceptions are former testimony exception, present sense impressions, present state of mind, statements of past or present mental or physical condition made for medical diagnosis or treatment, business records exception, public records exception, and judgments of previous convictions. Admission of a party opponent is a statement by a party or by someone whose statement gets attributed to that party offered by the party opponent. In this case, the prosecution is attempting to introduce Miller's silence to the bartender's statement that he must have robbed the bank as an admission by a party opponent. However, since Miller had no reason to reply to the bartender's statement, this evidence is in fact inadmissible. Let's look at the other options here. A, admissible to prove that Miller's conduct caused the bartender to believe that Miller robbed the bank. Whether the bartender believed he robbed the bank or didn't is entirely irrelevant and misses the entirety of the point. You would not have a witness which would be testifying to whether someone else believed something. The belief of that third-party person is irrelevant to the proceedings. B, admissible as a statement made in the presence of the defendant. Any statement made in the presence of the defendant, again, would be irrelevant. What would that be proving? Could you also try to throw in under this imaginary rule that someone else mentioned that the Kennedy assassination was also under similar circumstances? And would that then create liability for that? Obviously, that would be beyond ridiculous, but so is B as an option. C, inadmissible because it would violate Miller's privilege against self-incrimination. His silence, in fact, shouldn't be taken as a statement whatsoever. He's under no duty to respond to questions. As a matter of fact, if he had been questioned by the police, he would have been read Miranda rights, which gave him the opportunity to remain silent. So as a result, even under the most difficult of circumstances and being questioned by the police, the defendant would have every right to remain silent and not respond to these questions. So under this regular everyday scenario, when an individual literally has no right to ask another individual anything, C would be also irrelevant and D would be the only probable and possible correct answer. Question number 8. Dorfman's dog ran into the street in front of Dorfman's home and began chasing cars. Peterson, who was driving a car on the street, swerved to avoid hitting the dog, struck a telephone pole, and was injured. If Peterson asserts a claim against Dorfman, will Peterson prevail? A, yes, because Dorfman's dog was a cause and fact of Peterson's injury. B, yes, if Dorfman knew his dog had a propensity to chase cars and did not restrain it. C, no, because a dog is a domestic animal. Or D, no, unless a statute or ordinance made it unlawful for the owner to allow a dog to be unleashed on a public street. Take 10 seconds and choose the best option now. This was a bit tricky. I hope you chose option B. Yes, if Dorfman knew his dog had a propensity to chase cars and did not restrain it. Remember, to establish a prima facie case of negligence, the plaintiff must prove duty, breach of that duty, causation, and actual damages. The duty of care is a legal duty requiring the defendant to act according to a certain standard to protect a plaintiff against an unreasonable risk of injury. A duty of care is owed to all foreseeable plaintiffs, and to the extent that this duty is determined by the applicable standard of care. The basic standard of care is that of a reasonable person of ordinary prudence in the defendant's position. Here, Peterson would assert a claim under a negligence theory against Dorfman. One way Dorfman could have breached his duty of care to Peterson is if Dorfman knew about his dog's propensity to chase cars but did not restrain the dog from doing so. A reasonable person of ordinary prudence in Dorfman's position would have restrained the dog. By failing to do so, Dorfman would be in breach of his duty of care to protect drivers like Peterson against an unreasonable risk of injury from an accident caused by Dorfman's dog running into the street. Accordingly, Peterson will prevail against Dorfman if Dorfman knew his dog had a propensity to chase cars and did not restrain it. Let's look at option A. Yes, because Dorfman's dog was a cause and fact of Peterson's injury. It's true, the facts do tell us that the dog was the cause and fact of the injury. However, the cause and fact is not the standard we're looking for. The individual would have had to have violated a duty to the other individual in order to be held liable. The only way that there could be a duty would be if there was some prior knowledge of the dog's propensity and there was a failure to act accordingly. Let's look at option C. No, because a dog is a domestic animal. I'm not certain where that comes from or where the logic there is, but generally owners can be liable for the actions of their domestic animals just like they can be for the actions of their children. That being said, generally the standard is whether the individual behaves reasonably given the circumstances. Finally, D, no, unless a statute or ordinance made it unlawful for the owner to allow a dog to be unleashed on a public street. Again, that's not the standard. We're not looking at whether there is an ordinance or not, or nor should there have to be. The question is whether the owner of the dog, in fact, behaved reasonably. That is the sole question here with regards to negligence. So the correct answer as a result would be B. Question number 9. Barnes was hired as an assistant professor of mathematics at Riordan State College and is now in his third consecutive one-year contract. Under state law, he cannot acquire tenure until after 5 consecutive annual contracts. In his third year, Barnes was notified that he was not being rehired for the following year. Applicable state law and college rules did not require either a statement of reasons or a hearing, and in fact, neither was offered to Barnes. Which of the following, if established, most strongly supports the college in refusing to give Barnes a statement of reasons or an opportunity for a hearing? A. Barnes's academic performance had been substandard. B. A speech he made that was critical of administration policies violated a college regulation concerning teacher behavior. C. Barnes worked at the college for less than 5 years. Or D. Barnes could be replaced with a more competent teacher. Take 10 seconds and choose what you believe to be the best answer now. If you chose option C, Barnes worked at the college for less than 5 years, you'd be correct. Procedural due process requires that the government provide a fair process before it may deprive a person of life, liberty, or property. In order for an individual to succeed in an action for loss of property, a loss of an entitlement is required. An entitlement is a reasonable expectation of continued receipt of a benefit. In this case, Barnes was an assistant professor at Riordan State College for 3 years. But under state law, a professor cannot acquire tenure until after 5 consecutive annual contracts. As such, Barnes does not have a constitutionally protected property right in continued employment. If he had acquired tenure, Barnes would have been constitutionally entitled to a pre-termination hearing. However, since Barnes was not tenured, the best argument for refusing to give Barnes a statement of reasons or an opportunity for a hearing is that Barnes in fact worked at the college for less than 5 years and was not tenured, so they didn't have to. If we look at options A, B, and D, they fall into the same category. They in essence ignore the key turning issue, which is the 5-year tenure requirement. So as a result, they would be inaccurate, and D would, C would be the most appropriate response. Question number 10, the last question in this grouping. Miller's tried for armed robbery of the First Bank of City. At the request of police, the teller who was robbed prepared a sketch bearing a strong likeness to Miller, but the teller died in an automobile accident before Miller was arrested. At the trial, the prosecution offers the sketch. The sketch is A, admissible as an identification of a person after perceiving him, B, admissible as a past recollection recorded, C, inadmissible as hearsay not within any exception, or D, inadmissible as an opinion of the teller. Take 10 seconds. If you chose option C, inadmissible as hearsay not within any exception, you'd be correct. Hearsay, as you remember, is an out-of-court statement offered to prove the truth of the matter asserted in that statement. The general rule is that a prior statement by a witness identifying a person after perceiving that person is not hearsay and is admissible. However, for this rule to apply, the declarant must be subject to cross-examination. The hearsay exemptions are admission of a party opponent, vicarious party admissions, and prior statements by a witness. The hearsay exceptions are former testimony exception, present sense impression, present state of mind, statements of past or present mental or physical condition made for medical diagnosis or treatment, business records, public records, and judgments of previous convictions. In this case, the teller sketch is hearsay because the sketch was made outside of court. It is being offered to prove the truth of the matter asserted, and the teller is not subject to cross-examination. As such, the sketch would only be admissible as hearsay, exception or exemption, but the sketch does not fall within any of those exemptions or exceptions. So as a result, C would be the only correct option. Thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam, 10 questions at a time. As we always note, to that end, we do that by uploading content every day at 8 a.m. Eastern Standard Time, sometimes more content than that. Please like, subscribe, and ring the notification bell, especially if you like the content, so we know to produce more. Looking forward to seeing you again.